Welcome to the fourth session. I'm Maimon Schwarzschild from San Diego, and we're very pleased in this session to have James Ely's paper and James Ely on the contract clause. In the vast brick-like standard textbook that I sometimes teach constitutional law out of, the contract clause gets precisely 4 pages. There's one sentence on the Dartmouth College case. There's one sentence on the Charles River Bridge case. There's a little excerpt from Blaisdell. There's a very grudging little excerpt from Spanhaus, and that's it. It deserves more than that, perhaps, and I'm pleased that we have a chance with James' paper to get into that today. So the usual rules. James.
Thank you. Well, I must say that given its lowly status in current constitutional law, I'm pleased to hear the contract clause got even 4 pages in the book that you're using. Frequently, it's ignored altogether. Some years ago at Vandy, I hired a very good student as a research assistant, said I was doing a contract clause project, and said they hadn't even talked about it in his class. Shows you the state of constitutional law at Vanderbilt. Now, here's your chance to look at a real legal history geek, someone who spent the last several years of his life assembling material and reading heaven knows how many cases and articles and pamphlets and critiques of a provision which isn't really very lively today. But at one time, it was in fact a much litigated and very lively provision of the Constitution, and I decided several years ago that it needed a fresh look. So I am in the process, I'd like to think, of completing a book on the contract clause. What you have before you is the first chapter. I should also caution, before I say anything further, that I may be the only person in this room who does not have a theory as to how the Constitution should be interpreted. That is not the purpose of my enterprise. I am simply looking at the historical origins and early development of what was, certainly at least throughout the 19th century, a very important provision of the Constitution. Now, as the paper, I think, endeavors to undertake, I try to describe how the contract clause wound its way by a somewhat circuitous route into the Constitution. It is interesting that the contract clause, unlike, let's say, the takings clause of the Fifth Amendment, did not have antecedents in English common law. This was something that was, in fact, really devised to deal with circumstances in the newly independent United States. It first made an appearance, although rather different word formulation, in the Northwest Ordinance, and then was adopted into the Constitution itself. First, as I have explained, the language of the Northwest Ordinance was voted down, but then miraculously recovered, and even somewhat broader wording, the contract clause appears in the Constitution. It was not extensively debated. The contract clause did not appear to have been a topic of enormous controversy during the ratification process. There were some comments, pro and con. Clearly, the immediate problem that the framers had in mind was the widespread interference with debtor-creditor relationships which the states employed in the years immediately following the break with Great Britain. The years after the break with Great Britain were essentially depression years for the United States, and state legislators engaged in simply an array of imaginative schemes, all designed at the end of the day to frustrate the collection of debts. Debts to their own citizens, debts to citizens of other states, and of course, debts owed to citizens abroad, primarily British creditors, many of whom reappeared after the War of the Revolution, and the debts hadn't gone away. They now expected to be paid. It is, I think, also noteworthy that despite its somewhat unusual route into the Constitution, the framers adopt the contract clause at the very time they have made a conscious decision not to adopt a Bill of Rights, and were in fact assuring people that we really didn't need a Bill of Rights. So clearly, at least some group of the framers attached considerable importance to the contract clause and the promise that it held out of contractual security. Now, there are some early cases, as I've described in the book, in the article, in the book as well. There are some early cases in which the courts do show interest in enforcing the contract clause. We associate the clause, and quite rightly, I think, in many respects, with the famous opinions of John Marshall, but he was not the first person to write about the contract clause. We have several early cases indicating that judges were going to take it seriously, several early cases which indicate that a variety of different types of contract might well be covered within the scope of the contract clause. Now, it seems to me, for purposes of this conference, perhaps the most interesting question, and the one that has vexed people for a long time, is what was intended to be the scope of the contract clause? Or put another way, did John Marshall inappropriately extend the reach of the contract clause to contracts to which states were parties, public contracts in the jargon of the day? Everyone agreed, of course, it was to cover private contracts between A and B, but what about states that entered into contracts of a wide variety? Were they to be covered also? Now, here I think one is plagued with the fragmentary nature of the evidence. I have tried to assemble all the commentators on the reach of the contract clause and have endeavored to assess, near the best I can, their take on this. The fact is that I cannot prove what the framers as a collective group or the ratifiers as a collective group thought about the reach of the contract clause. I am mystified, to some extent, by the fact that so many historians and commentators have come rather casually to the conclusion that clearly what they intended was only to cover private contracts. The phrase private contracts was used in the Northwest Ordinance. It was conspicuously dropped at the Constitutional Convention. And leading members of that convention, James Wilson, Alexander Hamilton, to mention two, clearly intended and discussed it in terms of covering all types of contracts. That doesn't necessarily mean they spoke for the others, of course. So in any event, I really came to the conclusion that Marshall's reading of the contract clause, which will be first set out in Fletcher v. Peck, which of course will be in the next exciting chapter of the volume, Marshall's opinion is defensible. It's a defensible reading of the evidence before him. I cannot prove that it is necessarily in accord with what all the framers thought. I'm not even clear all the framers had exactly the same idea as to what the reach of the contract clause would be. But I think that starting with Benjamin Wright's sort of classic work on the history of the contract clause, there's been a tendency to rather casually assume that it only was intended to reach private contracts, and therefore what Marshall did was in some sense illegitimate. It wasn't consistent, if you will, with the original intent. I think that overreads the evidence. I have a lot of respect for Benjamin Wright's work, but I do think there is something to the point that he was very much writing in the progressive era tradition, and the progressives on the whole showed little interest in any kind of economic rights, and on the whole showed very little interest in being too much constrained by what the Constitution said in any event. So I think that it is, to my mind, this early chapter highlights what could be a problem for the originalist approach. To my mind, the originalist approach must proceed on the assumption that we can actually identify an original meaning. In fact, there's even some discussion, I think, in Ian's paper about the original public meaning. Well, you can identify what certain key elite figures thought, and I think I've tried to do that, but what the public thought as a whole, I don't even know how you could take a stab at doing that in this time period, and I have not endeavored to do so. how do we decide what the framers thought about one fairly specific clause, which seems on the face fairly clear? There's a tremendous danger, I think, of sort of cherry-picking evidence to try to find historical evidence that justifies whatever conclusion the author may have in mind to start with. I've endeavored very hard not to do that. I'm not pushing a theory. I'm simply trying to uncover the historical record and to suggest in this chapter that there would be support for Marshall's reading of the contract clause as including public contracts. And in that vein, I treat the well-known opinion of Van Horn's lessee, in which Justice Patterson, who had been a member of the Philadelphia Convention, Justice Patterson pretty clearly suggests that the state of Pennsylvania was bound by land grants that it had made. And we have, of course, opinions by Alexander Hamilton to that effect. I realize Hamilton wrote his opinion in response to a client who had a definite interest, but Hamilton's opinion is nonetheless very important because Fletcher v. Peck, it's been widely suggested, was very closely modeled after Hamilton's opinion letter dealing with the Georgia Yazoo lands. So in any event, I would be interested, certainly if we could have some conversation about how to understand historical evidence, what to do when people in good faith can differ as to whether or not the contract clause was intended to cover both public and private contracts. My only word of caution is that I do think this is a topic that requires some investigation. All too often in the law review literature, people just assert that it was only intended to cover private contracts. Marshall was wrong, he was overreading it, and the only person they really cite, they apparently do no further investigation, they just cite Benjamin Wright. Well, with that, I will turn to our commentator.